Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. The originator of the most internet butthurt from a solo practitioner that I've ever even fathomed. The primogenitor of whiny people, here just for you. I'm here for you. I can't believe it. It doesn't matter what you say anymore, because whatever you say is wrong, and whatever you say will piss people off. And as soon as people, and by people I mean the earth, start to understand that's where we are, I think the better. The sooner the better that people realize that everything you say will be taken to the maximum negative by the people who desperately need it to be negative. That's what they need. So there you go. There you go. So I'm happy to be here today. I haven't even really been, like, I say this because I went on Twitter for the first time, like, in any substantive way about 15-20 minutes ago, and I realized that a bunch of people were mad about something I said. But the people who are mad about it are, of course, people who already hate me. So it's ringing a little hollow. Mahalo or whatever. Where are we? Oh my goodness. I'm getting things set up here still. Yeah, they're mad about a certain term that I used on Twitter. I used the term chimp out. What are you doing in here? Don't say names. Your sister?
My sister's crying. He wants my youngest sister.
Well, you guys don't you don't sleep in the same room. Well, is she going to be okay, or do I need to go deal with that? Okay. All right, I have to go deal with a sibling issue. I'll be right back. Oh my goodness. Oh my goodness. Sorry about that. So that was, turns out I get there and the little one had stopped crying completely and was basically asleep. So c'est la vie. So I described what was it? The activity that I saw on Twitter as a chimp out, which apparently, according to a bunch of racists on the Kick Vic side, has something to do with black people. Yet, I'm pretty sure almost everybody on the Kick Vic side, at least who's vocal, is as white as the driven snow. So I don't know where they got it. I don't really care. Doesn't matter. What do we say? I need like a flashing banner that said "Hoes mad" or what. I mean, come on. Oh. Face masks should be active. Should be active. I don't know why it wouldn't be. Let me oh, I don't know how to do these settings on the fly. Where are they? I'll give it a 30-second look. So anyway, they're mad about that, but they're mad about whatever I say. So it doesn't really matter. It doesn't really matter to me. They will always and forever be angry. Where is the... I don't know if I can do this on the fly. They changed how everything looks. They always change things. No. Widgets? Oh my god. They changed everything. I can't fix it right now, sorry. The masks may not be working tonight. I'll see if I can... I don't know why they were suddenly working last night, but are not working tonight. Oh, face mask settings. It's a big thing. The video device. That one. Yeah, everything should be set, but I don't know why it's not. Oh. Turn that off, maybe. Test. Let's test that one. Hey, see? They're apparently working. I don't know what changed. But, so there you go. There you go. What are we talking about today? We've got some stuff. We've got some stuff going on. We've got yes. So Funimation has filed some supplemental evidence. We've got a Rule 11 agreement. We've got there's a notice of hearing, but I'm not going through the notice of hearing. And then I see why the sloth is it's just high up on it's just way up there. That's the problem with it, maybe. It's a derogatory term now. Okay, so the other thing we've got is John Volney's vacation letter, and then Ty has made a motion to strike and disregard or disregard late filings. So we're going to talk about all those things. We're going to talk about all those things tonight. That's going to be great. Ace Attorney, when? I don't know. Things are very busy. Let's talk about the rest of the week. Tomorrow night, Chris from Bubba Fest will be on. We're going to be talking about Bubba Fest, hyping the show, talking about who's going to be there, the stuff that they've had to deal with Facebook. We're going to be talking about all of the drama that's been brought about by I guess people, just detractors of the show, and what someone who's trying to just put on a good show has to go through with in this culture of people who just won't let you try to earn a living. How's that? So we're gonna have Chris on. I've got someone to invite for Friday's show. Someone that I know many people like and has some great stories to talk about with me, but I don't want to say who it is, because they haven't confirmed yet, and that's my fault because I literally just sent the invite right now. So we're going to talk about that. I've got an announcement. Maybe a kayfabe announcement. State Bar of Texas, you're on notice. We're going to talk about the State Bar of Texas later in the show. A little bit later in the show. I've got a message to deliver to the State Bar of Texas. Or whatever. So that's fun. Yeah. Is it Chris Morgan? Chris from Bubba, is Chris Morgan the Bubba Fest guy? I don't know. Chris from Bubba Fest is the guy that's going to be on tomorrow. Chris was on before. Really liked him. Got along great. I'm very excited to go meet him and go to Bubba Fest. One thing, I suspect you guys want to see some coverage of these shows. Like, I'm going to Bubba Fest and HawaiiCon. Not Matsuri. Tug and Hirohei were streaming a lot mobily. I didn't really do that. I don't know. It's weird. It's not like my style, right? My style is sit down and yell a bunch of things at the camera. So I don't know. Maybe I got to figure out how to cover the show in some meaningful way to you guys. But that's the plan. But anyway, so that's what's coming up. Should we just jump into it? We got a couple chats and then we can jump into it. That'd be great. This show might be a little shorter tonight. I don't know. I haven't as I look at the first document and it's 28 pages, I realize that is probably a stupid thing to say. The show may be a little short tonight just because I'm not sure how much we're really going to get into this stuff. Why is... Oh my goodness. Uh-oh. Okay. Well, Windows Explorer has stopped working. Oh, great. It's fixed now. And by fixed, I mean it's definitely not fixed. So there's a Rule 11 agreement. We've got vacation letter. Talk a little bit about that vacation letter. And then the motion to strike. Oh, 5 lean pages. Maybe we will be done early tonight. Who knows? Who knows? If we're done early tonight, I'll be over on Twitch. Afterwards, I'll announce that. I'm on a quest. I'm on a very important quest that has nothing to do with pettiness or personal mockery of a specific person. In no way do I want to have 7,500 plus subscribers just to be more prominent on Twitch than Maddox. Not subscribers, followers. So I definitely don't want to have more followers on Twitch than Maddox, and that's definitely not why I'm asking people to just go over, follow me on Twitch, for even if you never watch it. It's just, I just want to point out where Maddox is in the world right now. Because he's being such an insufferable pile of garbage. So that's not Internet Explorer, Windows Explorer, the file management system. Oh my god. So yeah. So if you are at all inclined, plus sometimes I stream stuff on Twitch. Last night, I won't do it tonight because my stomach is still recovering. Last night, for every time I died on Risk of Rain, except for the last 2, because I was really thoroughly in pain at the point, I was eating handfuls of volcano dust, which is a mix of habanero, red peppers, and boot jalokia, which is the ghost pepper. And I was doing that in training for the Carolina Reaper pod that I will be eating on the 75K subscriber special. So sometimes I do stupid stuff like that too. Twitch is very laid back and very different from YouTube, which is entirely serious all the time, as you can tell. Okay, so that said, let's get into these chats and then let's get into the documents. Put it on paper. Bad Vibe says, for one Lemoyne dirty limerick. Oh, did you send me? Somebody sent me a dirty limerick. Here we go. So this is a bit that came up during Twitch last night. Someone, I don't even know who. I think someone wanted me to find a way to convince Lemoyne to read a dirty limerick in court. So we're gonna say dirty limericks in Lemoyne's voice and see if we can maybe get him in there. So this one was sent to me by Sook. Says, there once was a man named Lemoyne that was butthurt by a 4-year attorney, fueled by whiskey and rage, made fun of Ron's cage, and taunts Kick Vic with his enormous GoFundMe. So that one's not particularly dirty, but it was a limerick that will probably cause him severe pain because it mentions the GoFundMe and refers to Ron as a cuck. So there you go. So if you guys have dirty limericks for Lemoyne to read, you know, there are ways to get them to me. HB says, Steer, we have no case, and one lawyer keeps pissing off the judge, and the others left. Steer says, we have no case, and one lawyer keeps pissing off the judge, and the others left. Blue Orca says, don't worry, we'll pull something out of our butt like we always do. A distant voice responds, and it shall be Ty Beard's boot. There you go. Mr. Ruby Elf says, hey, buddy, as an actual alcoholic, I've hated the fact that the Kick Vickers accuse you of being an alcoholic as you don't exhibit any signs at all of being one. I just got out of rehab for relapsing. Take my alcohol money and get yourself something good. Hey, thank you. Thank you. And thanks for noticing. I have, you know, I hope that if I ever do exhibit the signs of an actual alcoholic, that the people in my life will quickly step in. But I'm never going to take the advice of someone who calls me a horrific, hateful, misogynist, racist pile of trash. And then, by the way, you may want to take my advice on your life choices. Oh, right. You got it. Yes. And yes, the GoFundMe. I am going to shill the GoFundMe here because I don't have Ty on the show. I can actually shill the GoFundMe. So we are going to talk about that. The link, of course, to the GoFundMe is in the top of the description. Here's this. Let me pull up the GoFundMe real quick. Whoops. And I think I had a discussion with Ken, the guy making the knives. If you don't remember the knives, let me pull up the knives again real quick before we get too into it. We have 2 of the 3. The third knife is coming, and I'll tell you about the third knife in just a second. So here's the first one. It is a what is this? Probably a 3.5-4-inch blade. This one's not as they're fairly well balanced, right? Woohoo! Don't want to drop that on the old leg, but they're out there. I think the other one's a little bit better balanced. These are sturdy, high carbon steel. They need to be oiled and taken care of. They are not. These are not like little stamped out blades, right? These are real. They're sharp-ish. Do I have something I could cut? Let's see what we got. I think I guess I haven't actually done the paper test on it. How about this Highlights magazine? They're not razor sharp, but they are. I mean, they're sharp. I'm sure they can be honed even further if you wanted to, but that's probably not safe around the children. Anyway, so they are cool. They're substantial though. That's my point. Is they're not like a cheap little knockoff knife, and the sheaths are handmade leather. Although I believe that the third one is coming in a different type of sheath. Here is the second one. Its blade is considerably larger. You can see here, probably 5.5, 6 inches. I don't know. Is that about average, guys? Again, a pretty balanced blade. Full tang on these things. Again, not. These are well made. That said, the next thing Yeah, knife is a knife boomer. Knife boomer. The reason I'm bringing this one out, I can't show you the third one yet. It's about 2 of these, right? So we're talking, it's like a little sword. So my idea is to have a period of time where people donate to the GoFundMe. I'll designate a period of time, and the highest donations during that period will get period of highest 3 donations in order during that period of time will get the knives. Boom, boom, boom. For people who use their real names. So that'll be, I will announce this ahead of time. That's the plan. So so there you go. That's how that's gonna work. I'm not keeping any of the knives. I think they're awesome, but you know, it's these are for promoting the GoFundMe and for helping Vic. This is from someone who's not able to donate money but is able to donate time and craftsmanship. So very cool. Very cool. So what's next? Oh. So that mask, by the way, they don't tell me who actually donates with the masks, but Anonymous, whoever did the mask, said, even the universe hates Shane. Can we get an F in chat for Chair Coon? Destroyed by Shane's black hole. And yeah, if you guys don't know, this is a real story from the real physical science field of astronomy, where they really did discover it's the largest black hole measured by direct measurement rather than indirect measurements. So indirect measurements involve measuring the things around the black hole and how they're interacting, and that's how they determine how many solar masses a black hole is. Direct measurement uses some other thing that I don't really understand, but long story short, the largest direct measured black hole in the known universe is in the center of the Holmberg galaxy. So because God has a sense of humor, he put the largest ultra dense high gravity object that is a void of light, he put it in the Holmberg galaxy right there. So there you go. So there's that. Can't understand. Swarm 069 says, well, at least it's a projection on the dome or whatever. Swarm 069 says, did you see the video of Democratic Socialists of America convention? I did. Oh my God, it was great. It's like something out of a South Park or Monty Python. These dweebs want a revolution but are triggered by clapping. And gendered language addressing entire groups of people. Can't do that. Mythos Irving says, my mask I sent better not say the hacker group. It did. Yeah, it does. Sorry, Mythos. But thank you for sending the mask. But yeah, I don't know what it is about the masks. They always come up as anonymous. I don't have a way to change that, I don't think. Nope. I got nothing. There's not even a setting for me to mess with. And Dirk Lemon says, oh no, do you have a license for that knife, mate? The UK audience can't be exposed to such pro-knife propaganda. Just curious, what's your favorite truck? Also Trump 2020. I'm not a huge truck guy, but the new Dodge Rams, one of my buddies works at a Dodge dealership. New Dodge Rams, I drove one while my van was getting an oil change, and I drove around a 2019 Dodge Ram for a day, and God, it was really nice and quiet. It felt like a car in there. But I don't really have a favorite truck. Mr. Ruby Elf says, have you heard about the lawsuit of Perry? I think it would be interesting to get a copyright lawyer and a musician Katy Perry, right? Copyright lawyer and a musician as a guest on your show to talk about it. Possibly. Polar Bear Diego says, "Hey Nick, have you seen the latest news on Manja Monpedo? Is it true that she actually has perjured herself since she claimed to see misbehave when she was supposed to be in Japan? It doesn't look good for Manja." Presenting someone else's notes as your own eyewitness testimony, not the smartest thing to do. And then Nick Sex says, "That's been one consistent thing I've found with comics professionals is all of them seem to be legal experts. It's amazing." Nick Rekieta, Vox ruins the day. September 5th, aka the birth of law Twitter. Oh God. Jamal Eigel, attorney at law, is yeah. Also, bird expert Jamal Eigel. Very good. Very good. Yeah, I have a van. I have a 12-passenger van. Got more children. They don't... if you guys don't know, your kids have to be in like car seats or booster seats until they're like 10 now. So there was a point where we had 5 children in a car seat or booster seat, and that doesn't fit in a van. It doesn't really fit in like a Suburban or anything like that. Plus, you run out of room to put stuff. So, or a minivan. Doesn't fit in a minivan. So we do have a giant. We have a giant van. So there you go. Okay, I think that's it. Let's get back to these documents. Oh, but the GoFundMe. The GoFundMe. I all of that for this. All of that to say this. Here's the GoFundMe. We're at $236,890. Donations still continue to come in daily, and thank you all for that. Thank you all for that. We have some donations from Anonymous. Alan Donatelli, another Anonymous. Anthony Bennington. Stephen Pakaki. Oh, that one, I think I read that one the other day. Dave Myers. Chad Thundercock. Very fortunately named Chad Thundercock. I have a feeling that number will be $20 less soon. So there you go. That's where we're at on the GoFundMe. Thank you all again for contributing to that. You can find the link in the description, of course, as always, or you can find it pinned on my Twitter profile. I'm waiting on the updates. Like right now, the last update I did was a month ago, and that was when we upped it to 300,000 for the goal. I'll probably do an update as... I was going to wait until TCPAs come in, but that could be as early as October or as late as October. So we'll see. I'll find a time to do an update. But yeah. So that's that. And then you know, I believe the donation drive that involved the knives will comply with GoFundMe's terms of service. I have read it very carefully. It is not in any way being a payment processor for an auction or anything like that. The knives will be presented as a thank you to the highest bidder over a period of time. Highest donor over a period of time. Now they got me thinking auctions. It complies with the terms of service in my read of it. And so, you know, that the GoFundMe specifically told me that I could not do an auction, and I am not doing an auction in any way. So I've crafted this way to comply with the terms of service to the best of my ability. And if they mess with it, then I would not recommend it. Mythos Irving says, "Sadly, I must go to bed. Got a busy day tomorrow. Just had to stop by and point out the fact that God himself truly hates Shane, has a sense of humor." Yes, he does. He does. Okay. Let's go ahead and get in. Let's get in deep to these documents. Take something off. Oh, because of the money? Well, I'm just shoving it in my G-string. All right, so the first one we've got here is Defendant Funimation Production LLC's supplemental evidence in support of its TCPA motion to dismiss. We're gonna spend a little time marinating in this. This is gonna be fun. When is the courtroom? The first court date is September 6th. The next court date, September 6th. Although I'm guessing there's actually going to be a hearing before September 6th. And I would bet that hearing is going to take place really quickly. We'll probably find out about it tomorrow. If I had to guess by Ty's filing here, this motion to strike or disregard pleadings, I believe they ask for, they order defendants not to file any further affidavits or evidence as well. Or they're asking the court to do that. I'm guessing they're going to be pushing for a hearing as early as possible, maybe even this coming week. So we'll see. We'll talk about that. So defendant Funimation Production LLC submits the attached supplemental affidavits of Karen Mika and Scott Barreto. Wait. I thought Karen Mika and Scott Barreto already submitted affidavits. What's this? And those affidavits were devastating. Oh man, how on earth can Vic win when Karen Mika and Scott Barreto submitted affidavits? Funimation's in the clear, right? Remember this? Funimation is definitely going to win because they have these rock solid affidavits. Boy, is Ty stupid to file a motion to strike portions of the affidavit. Man, that's dumb. Why would anybody do that? These affidavits are definitely admissible, will definitely not be stricken. They will definitely win the TCPA motion. So there is no reason that it is perfectly fine the way they are and Funimation is home free. What is Ty doing? So now Funimation is going ahead and submitting brand new affidavits from brand new affiants, Karen Mika and Scott Barreto. Let's take a look at them, shall we? These affidavits are intended to address the objections made in plaintiff's objections and motion to strike evidence filed on July 24th. Why? Why would they be? Why would they need to do this? They were great the way they were. Here's the problem, of course. Their deadline to file the TCPA expired 60 days after service. Funimation negotiated via Rule 11 agreement their service date, and therefore they set Funimation and Ty combined agreed to a delayed service date specifically, and it gave Funimation 60 days from that point to file their TCPA. So there you go. Now what they want to do, they wanted to wait until the last day of their deadline because they wanted to participate in a deposition that should have had nothing to do with TCPA. I mean, the idea of a TCPA is to strike down a frivolous lawsuit. So in theory, if you have a frivolous lawsuit, the day you get served, the object of the TCPA is to allow someone on the very next day to file a TCPA and prevail because the suit is without merit. That's the goal. That's not how the TCPA ends up functioning. Now the TCPA is a sledgehammer that does not dismiss frivolous lawsuits, but often dismisses meritorious lawsuits based on the availability of evidence and the ability to foreclose discovery. But that's just my opinion. It also relies on judges to litigate facts without all of the traditional avenues for determining facts. So that's great. Prior to any sort of trial and without a jury. Anyway, personal beef of the TCPA aside, they decided to wait and take advantage of the fact that they would get to hear Vic's deposition and participate in it and hear the depositions of the other parties. But they did go ahead and file 1 day prior to their discovery production deadline. So they've produced no discovery during this. They just want to abuse the TCPA in this way. And now they want to have Now they want to have their cake and eat it too. They want to have filed within their 60-day window and shut off discovery, but now they want to bring additional facts into the equation after that deadline for filing. So think about how this could function. Hypothetically, you could file a shell of a TCPA motion on day 60, causing the maximum amount of harm to the plaintiff, racking up the maximum amount of billable hours that you'll then ask for in attorney's fees, and then set the hearing 30 days out because the judge has, or no, the judge has to hear it within 60 days. You can set the hearing even up to 60 days out, and then every single day supplement your motion, and then the other party has to respond to every single supplement that you file and every single thing. And so even as they're crafting their TCPA response, they would have to respond to everything that you supplement, go back and redo it, reincorporate things. It's just not a very clean way of doing this. There's no scheduling order in place. There are no hard deadlines set in the TCPA statute, so, except for the 60-day filing deadline, the 60-day hearing deadline, and the 30-day ruling deadline. So we'll see how this goes for them. But this is their extra evidence, even though their other evidence was real good. It was just fine. Let's see. We've got the supplemental affidavit of Karen Mika. Maybe I should pull up the other affidavit of Karen Mika. Let me see if I have this. Should have. Hold on. I can never actually find these. Funimation's TCPA motion. We'll pull up the original. We'll do a little bit of a comparison and contrast. Karen Mika. Okay. Okay, here we go. For me, the undersigned notary public personally appeared, Karen Mika. My name is Karen Mika. I'm over 18 years of age, am of sound mind, and fully competent to make this affidavit. The facts stated here are within my personal knowledge and are true and correct. I'm providing this supplemental affidavit to offer additional facts in support of my prior affidavit executed on June 28th, 2019. Oh man, if only you'd have included these facts prior to having them file a motion to strike your supplemental or your original affidavit, right? If only you had provided these facts first and not in response to the other side pointing out your definite not deficiency. You won't be able to read the side by side. I'm going to switch back and forth as we go. But I think, what is this? Oh, that's empty. What do we got? I think we need some Aberlour Abudna here to help get through this document. A TCPA is the Texas Citizens Participation Act. It is a SLAP motion. A SLAP is a strategic lawsuit against public participation. The idea is that some people bring lawsuits specifically to infringe upon the right to speak, protected speech. A meritorious defamation action is not a SLAP. It can't be, because defamation is not protected free speech. So if you have a meritorious defamation action, it is not a SLAP, even though the SLAP does strike down what would be defamatory speech in several instances because it's a procedural motion that is a mess. Either way, that's what it is. So it's a lawsuit that is designed to stop people's participation in free speech. and their First Amendment rights. So they're alleging by motion that Vic is imposing upon these poor women that need to be ground into dust by keeping them from speaking. Which definitely, even though that's not the relief requested, there is no relief requested to stop them from speaking. Has Rackets ever run out of booze? Yeah. I think so. I don't know. Hey, what's up, Tess? How you doing? Okay. Okay. Here we go. So we will go kind of one by one. That was the first paragraph is substantially similar. Notice a difference in second paragraphs here. Several lines have been added. So we're going to go through that. We've got, I am Vice President of Operations at Funimation Productions, LLC. I've worked for Funimation since March 2016. As Vice President of Operations, I am in charge of distribution and production of the dubbed anime videos produced by Funimation. In doing so, I oversee Funimation's contracting with voice actors, including with plaintiff Vic Mignogna, with Monica Rial and Jamie Marchi. For that reason, I am personally familiar with the business relationship between Funimation and Mignogna, Rial, and Marchi, including the scope of services Mignogna, Rial, and Marchi provided to Funimation and how they are compensated by Funimation. In addition, I am the ultimate decision maker at Funimation with respect to any decision by the company to terminate its business relationship with any of its voice actors. This is going to be the new stuff here, the new stuff that matters. I mean, talking about the compensation, this is her way of trying to get in their contracts, which are coming, but this is her authority on the termination. Because back here, she says that I am familiar with business practices and its business relationships with its employees and independent contractors, including with the voice actors who work for Funimation. Now, notice what she does here. They ditch this language. Why, oh why, would Funimation be concerned with ditching employees and independent contractors? Language from their original thing. They want to make this much more specific about the relationship between these three people. I don't think they want that idea of employer and independent contractor brought up. And here's why. We talked about this actually when we were redacting Karen Mika's affidavit. She says, where was it? She says they are independent contractors. And they do not hold any of them out as employee or agent. That they can say that they don't hold them out as employee or agent. Saying they're independent contractors rather than employees, that is a legal conclusion. They actually she can't make that. Toye is not an employee or agent of Funimation. That's a legal conclusion as well. Let's see if she did any better. All right. On or about January 16th, 2019. In my role as Vice President of Operations at Funimation. Someone's asking if I'm going to redline this. No, because I want to see what the court does. There's a motion, we'll cover Ty's motion to strike the entirety of any of these untimely filings. So that's coming. On or about January 16th, 2019, in my role as Vice President of Operations at Funimation, I was made aware of negative media and social media attention surrounding Vic Mignogna after the release of Dragon Ball Super Broly. Now, in my role, I was made aware that doesn't actually adequately state how this occurred. In my role, I was made aware. I don't know. In my role. See, that was one of the things we talked about. She didn't lay the foundation as to why. And this is a requirement of affidavits in Texas when they're giving any type of opinion, or even if they're trying to relay themselves as a business source of how they came into this type of knowledge. They have to explain how their role got them there, how they became personally knowledgeable of the facts they're attesting to, because you can't just say, well, I became aware of this. Well, why did, I'm the janitor. I know that Vic was fired. Well, how did you become aware that Vic was fired, and what is your job as a janitor to do for that? So in my role as Funimation's Vice President of Operations, I was responsible for directing Funimation's Human Resources Manager, Trina Simon, to contact Sony Pictures Entertainment to request an investigation of Vic Mignogna. Still doesn't actually explain this at all. So that's interesting. Which Miss Simon did. Because of my job duties and my involvement in requesting the investigation, I am aware that Tammy Denbo at Sony Pictures Entertainment conducted an investigation of Vic Mignogna. That's good. Tammy Denbo reported the results of her investigation to me, and I was the person who made the decision to terminate Mr. Mignogna's contract with Funimation as a result of the investigation. Wait a minute. That's interesting, right? This is interesting. I was the person at Funimation who communicated Funimation's decision to terminate him to Mr. Mignogna via telephone. Well. What'd she say back here about terminating? Based on Ms. Denbo's investigation, I concluded that Funimation should terminate its relationship. See, it's very interesting that they're admitting to that here, but Scott Barreto is saying something different. So we'll see how that goes. As stated above, see, her basing, now, there's a difference between this being an inadmissible affidavit and this being inadmissible for the purpose of the TCPA. If it's untimely for the purpose of the TCPA, may ultimately be admissible. How this might come into play later is she is now stating that the decision to terminate was based on the investigative results of Tammy Denbo. They've just opened the door, find out what the actual investigation entailed, depose the investigator, depose participants to the investigation, find out what record of the investigation may exist. If this, again, assuming they pass TCPA, this affidavit very much could be the basis for getting a lot of information about that investigation. I'll be very curious to see what they find. As stated above, Jamie Markey and Monica Rial provide voice acting services to Funimation from time to time on an independent contractor basis. That is a legal conclusion. True and correct copy of Miss Markey's current work for hire actors agreement with Funimation is attached to my affidavit as Exhibit A. True and correct copies of Miss Rial's current work for hire actor agreements are attached to my affidavit as Exhibits B and C. The referenced exhibits have been redacted to exclude Miss Markey and Miss Rial's home addresses, social security numbers, and hourly rates. Funimation did not control or direct any of the Twitter or other social media posts made by Jamie Markey or Monica Rial about Vic Mignogna. That is actually not within her job duties. She can't make this claim because she didn't say that she's in charge of their social media, right? Of monitoring actors' social media or directing actors' social media. So still failing at this. Nor did Funimation control or direct any other communications made by Jamie Markey or Monica Rial about Vic Mignogna. So there you go. Those last statements are definitely problematic, we'll say. But the entire thing is on the chopping block for being untimely. Work for hire actors agreement. So here it is. This will probably be substantially similar to the contractor agreement that I provided with you. Let's see. FPL owns or controls the rights to various audiovisual. So these are the same so far. They blocked out the hourly rate. No royalties or residuals. Agreement shall be in effect beginning on the date of signing and ending on December 31st, 2017. Term shall automatically renew for successive one-year periods. Talent shall appear and voice act for a reasonable time as needed during the term of this agreement. However, nothing in this agreement shall be construed to obligate Funimation to provide talent. This, I don't think this contract ends up helping them. This is the same. This is the same as the, if you want a full rundown of this, I've actually gone through this entire contract in a video. I'm just I'm checking to see if there's any immediately noticeable differences. Let's see. These are the same. Confidential information is the same. Sole and exclusive right to talent services in connection with the property and materials. That's the same. This is the same. Governed in accordance with the state law of Texas and Tarrant County. That's the same. Written agreement is the entire agreement between the parties. Waiver. Same termination. Let's see. Upon written notice to talent. So again, she may have just solidified a breach of contract claim for Vic, because if he's terminated for cause, it has to be done according to this. So maybe he wasn't terminated for cause since it wasn't a written notice. She did mention that she communicated it to him by phone. She did not mention sending written notice to him. So that'll be, again, interesting. No waiver. So it's the same. I mean, the contract it's identical outside of dates and names and stuff like that. So then we're going to find probably something similar here for... Aha! This is different. Monica's got a minimum 2 hours of pay per recording session. So she has a minimum guarantee, effectively giving her a guarantee of 2 hours. This is in line with the Los Angeles union rates. The union talent is guaranteed a 2 hours of pay, 2 hour minimum. So she's got that. Marky doesn't have that protection. D, that's good. Good drafting there. Just an extra letter hanging out. Let's see. Other than that, these look the same. There's another affidavit coming up. I just want to see if there's anything specific that looks any different in this stuff. Nothing really. The only significant change I see is that one. Here's the for cause. Termination is the same here. All right. And then Exhibit C, Monica Rial again. So this is Dragon Ball Z Super. So this is including. So this must have been her agreement for the Dragon Ball Z Super, either the series or the movie. But this is clarifying that Dragon Ball Z Super is incorporated into this. And then here and after the series, they might have a specific term on the series. So same thing here. Oh, but she doesn't get a guarantee of, minimum 4 hours. 4 hours, here we go, for this one. So that's new there. Okay. Let's see. Work for hire, all materials. Let's... Confidential information. Oh my goodness. Oh, she doesn't have to initial this one. Sole and exclusive rights. You know, they clarify that it includes the series, but I don't see anything about the series being actually included in the document. But I am doing a quick skim. Maybe it's in here somewhere, but I don't see anything. So yeah, that's that. Long story short, their contracts have not significantly changed from the one that I displayed. Unreal Ent Gaming, it's Dragon Ball Z Super GT. Don't you mess with me. Want to fight? Want to fight? You know who I am? You know my name? Texan83 says, didn't you have an email from Monica to Funimation HR explaining who she is and informing them about Sony's investigation dated after they fired Vic? I mean, I do. I do have that. There you go. So, yeah. So here is the next one we've got here is the affidavit of Scott Barreto. There's Tammy Denbo. Looks like they couldn't get Tammy to redo hers, as far as I can tell. Just Scott Barreto. How much have you guys ever wanted to like donate a whole bunch of money to some place so you get your name like on a park bench or a playground or something, and then get just super hammered and stay there, like not being a pain or anything, but just staying there too long, and then have someone remove you only so you'd be like, you know who I am? You see my name on that slide? God, that's what I want to do. That's my life goal right there. I think that would please Twitter very much. I've watched a good chunk of Super Unreal Ent Gaming. I just haven't had time to go through all of it. I watched many episodes and lots of recaps. Lots of recaps. All right, so this is the affidavit of Scott Barreto. So we've got his. Oh, look at that. First paragraph is very different. Oh, but it's mainly they added that I'm providing the supplemental affidavit to offer additional information in support of my prior affidavit executed on June 28th. This is a funny line. The exhibits referenced in this affidavit are the same exhibits attached to my prior affidavit. And there's going to be a very specific change where Scott Barreto goes ahead and retroactively states that he pulled them on a specific day and refers to the original productions. Because even though he definitely 100%, because remember, Volney, Lemoyne, and Sam Johnson are the most competent attorneys in the room, and Ty's a bumbling idiot who doesn't know how to authenticate anything. They definitely correctly authenticated the documents, lol, except suddenly Volney felt the necessity to get updated affidavits which correct their authentication statements to make them actually valid because they actually weren't. How embarrassing is this? How embarrassing. Remember, the bumbling moron who doesn't know anything about court, trial, authentication, depositions, or anything said these aren't actually authenticated. Law Twitter comes running out of their glory hole stalls, running out to quickly defend the solid affidavits of everybody involved, and all of the evidence has definitely been authenticated. But the actual lawyers getting paid by the actual companies and people involved here who actually have their licenses and the case on the line come out and say, whoa, we're going to correct that statement because oops. I am Senior Director of Public Relations at Funimation LLC. Let's see, how many lines different is this? This is paragraph 2. Look at that. Paragraph 2 here. 1, 2, 3, 4, 4.5 lines. Here it's a whole freaking page. Let's check it out. I am Senior Director of Public Relations at Funimation Productions LLC, which position I have held since September of 2018. I have provided public relations related services to Funimation since 2015. As Senior Director of Public Relations at Funimation, I am familiar with Funimation's media and social media related activities, and I monitor media and social media posts related to Funimation. In my job, I am the chief spokesperson of Funimation. Super new. Why couldn't he have said that last time? I handle all outbound and inbound media inquiries for Funimation. I routinely draft press releases and press statements and review communications for Funimation's Twitter account at Funimation, which necessarily requires me to have knowledge of what's going on at Funimation with respect to its productions, its talent, and its corporate policies as part of my day-to-day activities at the company. As chief spokesperson for Funimation, my job duties also require me to be aware of all media attention related to Funimation's production and talent, including media attention to voice actors who appear in Funimation's productions. In my job, I regularly and actively monitor print and online media related to Funimation's business, including business, trade press, online news, and press about the anime industry and community. Hi, Scott. How are you? Welcome to the show. Well, I know you. Now I know you've been watching, homie. Now I know you've been watching. As chief spokesperson for Funimation, my job duties also require me to be aware of all media attention related to Funimation's production and talent, including media attention to voice actors who appear in Funimation's productions. In my job, I regularly and actively monitor print and online media related to Funimation's business, including business and trade press, online news, and press about the anime industry and community. I do so by performing searches, e.g. Google, and by regularly checking the websites for online publications and media outlets such as Anime News Network, Polygon, IO9, Screen Rant, Newsweek, and Variety. So there you go, among others. These are the go-tos for Scott Barreto. If you want the first 6 problems with Funimation right now, you want the first 6 problems, it is Anime News Network, Polygon, IO9, Screen Rant, Newsweek, and Variety. There you go. There you go. The mouthpiece of Funimation, the filthy, sullied mouthpiece, rife with Sony's gonorrhea, is Scott Barreto. Right there. My job duties also require me to monitor social media on a regular basis for information related to Funimation by using media monitoring tools such as Social Studio, TweetDeck, and Listen First. In the performance of my job duties at Funimation during 2019, I regularly monitored media and social media resources for information related to Vic Mignogna. Vic Mignogna. As I stated in my prior affidavit, allegations of misconduct against Mignogna began to receive media and social media attention in January 2019 with the publication of articles by Anime News Network and Polygon.com, as well as tweets and social media posts from members of the anime community. Remember, hey, Scott. Hey, Scott. Assuming this affidavit is still around, assuming Ty gets your whole affidavit stricken prior to TCPA, defeats TCPA, and then Funimation hasn't settled and fired you yet, Scott. And by the way, Scott, if you're looking for a new job, because guess what? You're gonna get fired for this. I'm just guessing. It's not you, buddy. It's not you. It's all y'all. That's the plural for y'all. Is all y'all at Funimation have your shaft on the chopping block, so to speak. There's going to be a trimming. That's what happens when major media companies or major companies buy up a smaller company. There tends to be some sort of culling already, but it's typically relegated to a select management staff that they find to be inefficient, or trimming the fat, so to speak. Or redundant communications departments. Might not need someone to monitor Funimation if they're already got a significant public relations department at Sony. But maybe you're still good. But here we go. let me just let you in on this. When there's a guy who admits to composing a tweet that drags a company into a lawsuit with a bunch of negative press and a bunch of angry fans who have canceled subscriptions and a bunch of people who are out there saying, we're not going to buy your product anymore because you guys are stupid. You're already on the chopping block for that. But now I got a question for you, Scotty. You said that you regularly prepare press releases. An anime news network cited sources within Funimation discussing the employment arrangements of Victor Mignogna prior to your announcement. Who communicates with Anime News Network at Funimation other than you, Scott? But hey, buddy, if you want to come on the show and tell your side of the story, email me. Also, after you get fired, if you want to come on the show and tell your side of the story, you're still welcome. I like you. I think you're cool. Let's see. As well as tweets and social media posts from members of the anime community. Who are these members of the anime? Like members of the anime community? Are you talking about con sluts? Are you talking about con sluts? Can I buy the bathwater of a con slut? Are you talking about con sluts? Are you talking about what's a member of the anime community? Are you talking about the 7 Mile armed ape? Are you talking about Slope Chest? Are you talking about Jesse Thoughtmore? Who are you talking about here? Are you talking about Han Leia? Are you talking about the English school teacher in Japan that is somehow a member of the anime community? What members of the anime community are we talking about? Who is it? Examples of such media attention were attached to my prior affidavit. During this same time and through today, supporters of Mignogna, many of whom adopted the hashtag #IStandWithVic, threatened and harassed members of the anime community and others who supported the women who alleged misconduct by Mignogna, who used the hashtag #KickVic. This is, you cannot actually make this claim. Harassment's a legal conclusion, Scott. You're not qualified to give a legal conclusion of harassment. Same with threats. Threats are legal conclusions. Threats are very serious, sometimes punishable by felonies. So I would hesitate from making those sorts of claims in your affidavit. Stay in your lane, Scott. Stay in your lane. Use the specifics. Say what they said. It's your time to shine, buddy. You get to talk and you don't do it. By late January, Funimation had received inquiries on social media and from the media whether Funimation... Did Funimation or did you? You're the link to the media, man. You're the gateway. You're the gateway. You're the chastity belt. You're the chastity belt for when Anime News Network wants to rape Funimation. You are the belt that stops them. Did you let him in? Who was it? Who was it? How did the company become aware? Whether Funimation intended to take any action or make any statement with respect to Mignogna. Due to the continued publicity surrounding Mignogna, including the allegations against him about inappropriate treatment of women referenced in the online media attached to my prior affidavit, Funimation decided to issue a short statement via Twitter regarding its decision to end its relationship with Mignogna, which Funimation did on February 11th, 2019. Note what's missing from the next line. I drafted Funimation's February 11, 2019 tweets in my role of Senior Director of Public Relations at Funimation. Scott, who made the decision to respond? Was it a board meeting? Were you present? Who ordered you to draft the statement? Drafting the statement is not making the statement with personal knowledge. It is drafting a statement. Who told you what to write? You wrote this in a way to not say that you made the decision. So who did? Who did, and why won't you just say it? War God 739 says, would supplementary material be more appropriate for an appeals court rather than leading up to the hearing on the TCPA? No, it's appropriate anytime other than after a filing deadline for material. If they beat TCPA, they can supplement with affidavits all day long. If Ty defeats them at TCPA and they move on, they can file all of the affidavits they want because there's no longer this deadline that's imposed by statute. If they win and Ty is forced to appeal, wouldn't it make more sense to amend to strengthen at the time? No, you want to get your arguments. You want to raise all of the issues that you can prior to appeal. You don't want to try and bring new facts and new information on appeal because the appeals court will rule on things as a matter of law and they will defer to the discretion of the trial court as the most appropriate party to determine matters of fact. So there you go. Oh, just an update I'm noticing in the chat. Your boy Zach's comic Jawbreaker's God King has 2 hours left and has just passed $190,000 on Indiegogo. Go check it out if you're looking to buy it during the campaign time and help him push his way into the top 3 of comics on Indiegogo. Go do it. Go. Excuse me. Get up there. Go help him out. All right. Back to here we are. Doesn't say who made the call. A true and correct copy of Funimation's tweets are attached to Funimation's TCPA motion as Exhibit L. Now listen. The purpose of the first tweet on February 11th was to inform the anime public of Funimation's decision to end its relationship with Mignana, which was a subject of public concern. That's a legal conclusion based on the public attention paid to the Mignana situation in the media and on social media. Strike, even if this affidavit survives, they're going to have to strike this sentence. Why, Scott? Why did you put a legal conclusion in? You're not qualified to make it. At the same time and in the same Twitter thread, Funimation added the following sentence to its tweet. Did Funimation or did you? Did you? You drafted all the tweets. Okay, so you did. Why are you saying Funimation added it? You did it. Part of our... Wait, did he? Did he now? Says he drafted it. Did he tweet it? Did he press yes? Very, very weirdly worded. Very weirdly worded. All of this stuff. Just say it. Funimation. If you haven't figured this out, guys, they're terrified right now. Funimation is absolutely terrified of what Ty has done to them so far, what you guys have done to them so far, and what they fear is coming in this TCPA. And by the way, no matter the reaming they've gotten so far, their sphincter is not elastic enough for what Sony will do to them if they lose this TCPA motion. They're going in dry, they're going in hard, and they are in no way apologizing or stopping for what comes next. Funimation is terrified of this. Funimation added the following sentence to its tweet. Part of our core mission is to celebrate the diversity of the anime community and to share our love for this genre and to support its positive impact on all. We do not condone any kind of harassment or threatening behavior being directed at anyone. The purpose of this additional tweet was to respond to the continued heated back and forth among anime fans about Mignana. Were you directed to make this tweet, Scott? and was an effort to encourage civility in the anime community. Were you directed to make either tweet? And then were you directed in the interim between the first and second tweet to respond? Because you're saying to respond to the continued heated back and forth. Funimation nowhere stated or implied in any of its tweets that Mignana had engaged in any harassment or intimidation, sexual or otherwise. I'm aware of the purpose of Funimation's tweets because I drafted them for the company in my role of Senior Director of Public Relations. That doesn't actually necessitate that he would know the purpose of them at all. Was he given a sheet of paper that said draft a tweet to deal with this issue? Draft a tweet that accomplishes this, this, and this. Scott, let me just tell you, if they directed you to draft a tweet to do what you just said, to do the intent, you should be fired. That was a bad tweet. That was a terrible tweet. But blame them for directing you to make a tweet that was unnecessary. Oh man, you know what, guys? Let me just... $150 million company. Some people on Twitter are saying we have to answer them. What are we going to do? Ignore it. Ignore it. Call your lawyer. Which you didn't, did you, Scott? Did you call Evan Stone? Did a single person call Evan Stone? Did you contact your legal department, Scott? When you get deposed, I guess you'll be asked that question. Did anybody for 1 second go, hold up? Should we listen to Twitter or should we contact the lawyer that we pay to protect our company? Did you contact Evan? Did you contact any other counsel? Which counsel signed off on this statement? Because I guarantee you that person would already be fired. But none of you did you? No one did. Which is why Evan isn't representing you in this case, isn't it? Isn't it, Scott? That's why you've got John Volney. Isn't it? Because Evan was probably like, who the hell did this? Why in God's name would you respond to random morons on Twitter with an announcement about firing an employee and why we did it? Why on earth would you tell anybody why we fired someone who isn't in prison already? And even then, maybe we want to keep it vague. But you didn't call anybody. Did you, Scott? God, I wonder if that question's going to come up when Scott gets deposed. Or at least, let me reiterate, I hope you didn't call, because any attorney who advised you to make those tweets should not only be fired, he should be disbarred, he should be disgraced, and he should go join Law Twitter. He should go be an academic attorney and join Law Twitter. Right? He shouldn't be allowed to practice. All right, next. Funimation's February 11th, 2019 tweets were truthful. Oh, okay. The self-serving assertion, conclusory assertion that they're truthful. In my role of Senior Director of Public Relations for Funimation, I am aware that an investigation of Mignana was conducted, that Funimation recast Mr. Mignana and Morose Mononoke in 2, and that Funimation will not be engaging Mr. Mignana in future productions. In addition, and for the same reason, I am aware that part of Funimation's core mission is to celebrate the diversity of the anime community and to share its love for this genre and its positive impact on all. As stated in Funimation's February 11th, 2019 tweet. Further, Funimation does not condone any kind of harassment or threatening behavior directed at anyone. Well, Scott, that doesn't seem to be true at all, does it? No statement by Funimation in its February 11th, 2019 tweets is intended to defame Mignana in any way. Nor do the statements imply that Mignana engaged in any harassing or threatening behavior. Funimation has not made any other public statement about Manana since its tweets on February 11th, 2019. Here they have a big dilemma. Karen Mika says she says that she made the decision to terminate Manana based on the investigation of Tammy Denbo. Let's take that as true. Okay? Let's take that as true. Now, under oath, under sworn affidavit, by the way, saying based on the investigation does not actually mean that he engaged in threatening or harassing behavior. So let's take Karen Mika's affidavit as true. And if you notice, all three of these affidavits can't actually be true at the same time. That's a problem. Now, Scott is saying the statements under oath, the statements do not and were not intended to imply that he engaged in any harassing or threatening behavior. Well, that's great, but it's not up to you on whether they imply that or not. It's up to a reasonable person's read of the substantial message of the statement. So a reasonable person concluding that means it is. So then, is that a lie? And if it's not a lie, how is it not a lie? If it's not intended to make the statement that it makes, isn't that a lie? I don't know. We'll have to see, I guess. True and correct copies of the following original online publications and tweets are attached to Funimation's TCPA motion. Now, this actually is still probably not sufficient to authenticate these things. Oh, wait, no. Here we go. No! I don't think this is sufficient. The above articles from the reference publications were obtained by searching the websites for each of the reference publications and by printing true and correct copies of the original articles from the reference dates and from the websites. Who did it, Scott? Notice the passive voice in all of this stuff. Why is there a passive voice? Okay. For the purposes of TCPA, just like in a summary judgment motion, the moving party is asking the court to do something. So then the court returns that favor by reading all evidence. All evidence. Affidavits are evidence, okay? All evidence in the light most favorable to the non-moving party. So, when we read this sentence with passive voice, in the light most favorable to the non-moving party, that'd be Vic. To the moving party, it'd be Funimation. Now, let's read this. Let's read this in the light most favorable to Funimation. Here's how the statement would read if it was favorable to Funimation. The above articles from the reference publications were obtained when I, Scott Barreto, searched the websites for each of the reference publications, printed true and correct copies of the original articles from the reference dates from the websites, and attached them to this affidavit. Online comments made of the articles were then excluded from the copies submitted to the court. True and correct copies of the above original tweets were obtained from Mignana's and Funimation's respective Twitter accounts when I went to those Twitter accounts, pulled the copies, and attached them to this affidavit. That's how it's read most favorably to Funimation, because that means that Scott is authenticating the product that he is purporting to be true and correct. Here's how you read it in the light most favorable to Vic. Okay? The above articles from the reference publications were obtained by someone at Funimation, someone else at Funimation, searching the websites for each of the reference publications by printing copies of the original articles and handing them to me and asserting that they were from the dates referenced. Online comments made of the articles were then excluded by the other person when we submitted them to court. True and correct copies of the above original tweets were assured to be provided to me by another Funimation employee from Manana and Funimation's respective Twitter accounts. That's how you read it in a light most favorable to Vic. It's written in a passive voice. And the inference of why you wouldn't just say, I did this, is because you didn't do it. Did you, Scott? Was it John Volney who gave them to you? Was it John Volney or was it Scott? Nothing wrong with John Volney doing it, so long as you actually assert your own knowledge of them to be true and correct by you verifying them. You do not have custody of the documents purporting to be an online production of a website unless you maintain that custody from start to finish, or you verified each document independently. You don't state that you did that. Why? Why? John, why didn't you have him state that he did that? Why is he writing in passive voice? Okay, and then all the affidavits are, or all of the exhibits are still there. We want to authenticate these unauthenticated exhibits by saying they're authentic after you pointed out that we didn't do it right. Well, we'll see. We'll see. Maybe the judge will allow this in. Absolutely possible. But I know how you make the argument to read it in the light most favorable to Vic. I like the Spike Man says, I'm glad knowing my degeneracy with cute two-dimensional girls is way less severe than these clowns fumbling in a bowling pin of a case. Funny as use artists who draw guro, rape, and loli. It's fam art. It's fam art is art. There you go. Kov says, she Shayet. Gotta check through all my affidavits. I've made an assistant PI to see if I've made any legal conclusions. Or I've made as an assistant PI to see if I've made any legal conclusions. What makes a good witness declaration affidavit for those of us who write them regularly and aren't lawyers? Well, the trick is actually what makes a good one is proofreading by the lawyer and by a good lawyer. But avoiding legal conclusions, avoiding any possible hearsay, stating everything from personal knowledge, and being very clear in how you obtained that personal knowledge. That's how you write a good affidavit. You have all of the documentation, all of the space in the world to talk about what you personally know and why you know it. You don't have is the space to say what other people told you to be true. And to say, I saw him raping someone. Well, did you see them raping someone? How do you know it's rape? That's a legal conclusion, right? Rape is a specifically defined thing. I saw him engaged in sexual activity with so-and-so that appeared forceful or something like that. And she appeared to be resisting something. I don't know. You don't make the legal conclusions. You can try and draw inference from your present mental state, but there's a whole bunch of rules of evidence that you can use as a guide. My recommendation would be have an attorney proofread it. There you go. Ma'am6 says, and here's the reason that this isn't a big thing, right? Here's the reason that this normally isn't a big thing. And probably why these attorneys get it wrong. Nobody normally is challenging these affidavits. Because hearsay rules are really complicated. Like really getting into what is and isn't hearsay is a mess. And a lot of lawyers get it wrong. Really getting into authentication, getting into the weeds of authentication can be a big mess. And most people don't bother with the fight over the authentication. Because if you both kind of agree on the fact that it happened, why argue over the authentication of the fact? But in this case, the facts are critically important to various... This is, in Law Twitter's defense, their argument is that nobody would argue over this stuff because they'd be doing this other, they'd be working on this other aspect of it. Well, here's the deal. Nobody, Beard, Harris, Bullock, and Hughes isn't everybody else, for one thing. They're extremely thorough, they're extremely competent, and they're extremely focused on providing the absolute maximum level of representation. Why do you think I said it in the GoFundMe? Why this firm? Because they're effective and aggressive and thorough. That's why. That's the mystery of Beard, Harris, Bullock, and Hughes. I solved it for you. I wrote it months ago. A lean, adaptable, capable firm. Period. And all of the lawyers out there saying, well, no one would argue over this. Yeah, I hire the guy who does do this. If I'm on the line, I hire the guy who does do this. So when I'm making a recommendation of an attorney to someone else, I'm recommending the guy who does every single thing to get me to win. Every single thing. And why in God's name you would hire any attorney other than the person who will fight the absolute hardest for you? The only answer you have better be because you can't afford it. That's the only answer. Your ass is on the line. You hire the person who will do the best job polishing that ass and making it presentable to the jury. Period, period, period. If any other lawyers told you otherwise, don't ever listen to them again. All right. Let's get to this Rule 11 agreement. So here's the Rule 11 agreement. This should be pretty straightforward. It's just 2 pages. Ma'am6 says, if Funny didn't intend to defame Vic, why didn't they just take down or correct the tweet when or before they got the TDMA letter? You have found it. That is right. Of course. Exactly. When they got the TDMA letter, immediately issue a clarification. Immediately issue a clarification. Why not? Oh, it's not intended to harm him. We're asserting that it caused harm, and if you don't correct it, we will sue you and ask for exemplary damages. No. Wait, what? Why not? Just clarify. Whoa, we just want to clarify. This isn't intended to defame Vic or suggest that he was engaged in sexual harassment or sexual assault of any kind or any threatening behavior. Done. Out of the lawsuit. By the way, not just prevent exemplary damages. If Funimation makes that statement, guess what? I put 95 to 5% chance. 95% chance that if Funimation would have, even up to today, I bet even up to today, if Funimation dropped their TCPA and made a clarifying statement to the world that says, we did not fire Victor Mignogna for any alleged harassment, assault, or threatening behavior. If Funimation made, and any statements to the contrary or any inferences to the contrary are not correct and were not our intention, we apologize for the confusion. I bet 95% certainty that Funimation walks away from this lawsuit today with $0. With $0 paid to Vic as compensation, and probably with no promises of any kind. No promise to employ, nothing. I bet Funimation could get that deal today. Because I'd give them that deal, most likely. It would sell the other people upriver. But why didn't they do it on the TCPA letter or TDMA letter? It's the biggest question that no dummies on Law Twitter will bother asking because the answer is troubling. The answer is really troubling. And all of the customers of Funimation should look at that answer and be troubled by it too. Hey, Funimation, if you didn't mean what everybody read, Why didn't you just correct everybody and say, whoa, we didn't mean that? Why didn't you correct your own employees? Why didn't you correct your own contractors? Why didn't you correct your own social media manager? Why didn't you correct Karen Mika? Why didn't you correct her? Why didn't you correct anybody? Why didn't you correct the conventions that you have, the conventions that you sponsor? Why didn't you correct the business partners that you have? Why haven't you corrected a single person? Because you're full of shit. And we all know it. We all know it. Because I know Ty, and I'm pretty sure Ty has asked you to pull down that statement and just let people do business. I could bet money that occurred, because Ty has said on this show, and he said in private to me over and over, the best way to resolve a business dispute is to just do business. And this is the least sensical employment decision ever. Not firing Vic. You have your own reasons for doing that. The least sensical employment and HR decision ever is making a tweet about it. Because, well, they're asking us to on Twitter. What are we going to do? It's Twitter. They'll get bored tomorrow. But you didn't let them get bored. All right. Counsel. Under Rule 11 of the Texas Rules of Civil Procedure, this will confirm our agreement regarding scheduling matters related to defendants' motions to dismiss under the Texas Citizens Participation Act. Parties agreed to the following. Plaintiff will file his responses to the TCPA motions and any objections or motions to strike on or before August 30th, 2019. Defendants will file their replies and any evidentiary objections in support of their TCPA motions and any objections, motions, to strikes on or before September 3rd. Hearing for defendant's motion to dismiss and any party's objections / motions to strikes, to the extent the court determines that it needs to hear arguments on any party's objections or motions to strike, are set for September 6th, 2019 at 10 a.m. They did preserve oral argument for the motions to strike. Plaintiff and Funimation agree that the 60-day TCPA hearing deadline for Funimation is extended to September 6, 2019. Plaintiff agrees that the hearing on plaintiff's motion to strike that is currently set for August 8, 2019 has been moved to September 6, 2019 as stated above. That's because Funimation's original deadline was August 30th to have the hearing. And that's a hard deadline. They have to get this in there. Please execute this agreement and email a copy back to me, Ty Beard, John Volney, Sam Johnson, Sean Lemoyne. Sean Lemoyne. The very basic Rule 11 agreement. It's all done. You just had an ad during the live stream? I don't know. I don't have an ad button, so sorry, buddy. That's how YouTube does it. All right. Vacation letter from Lynn Pinker Cox and Hurst. There's like a joke in there, I'm guessing. Oh, hey, asphyxiation. Maybe you could comment on why a Pinker Cox might hurt. You'll get the joke. You'll get the joke. All right. Oh, and by the way, that ad revenue won't be mine either. Every one of these, every live stream I do starts off demonetized. Just so we're clear, YouTube has done me that courtesy that literally every live stream I do starts demonetized and I have to appeal it to get any monetization, which happens, of course, like 4 or 5 days later, well after the peak viewing. So just so you know, if you want to use ad blockers while watching the show, you won't hurt my feelings at all. That's YouTube. Thanks YouTube. Happy about that. Dear Mr. Fisher, Mr. Fisher is Jeff Fisher, the court coordinator. I'm on a prepaid trip to Estes Park, Colorado with my family from August 14th to 16th and will not be available for any hearings in the matter. Hey, that's a fun place to be. Christian Orozco will be out of the country on August 15 to 16 to attend his brother's wedding and will not be available for any hearings in this matter. Oh, man. Shucks. What's next week? Let's see. So motions to strike filed today needs 3 days. That's 3 business days. Let's see. The 9th, the 12th, and the 13th would be 3 business days. So shockingly, the earliest date that Ty could file for a hearing on this motion is the 14th. And just goes right through the 15th and 16th for both of them. Man. So it just won't be available until 19th, 20th, 21st, 22nd, 23rd. I wonder who from whatchamacallit? I wonder if Sam Johnson's going to be out in September, but I wonder if Lemoyne, Casey Eric, and Andrea Perez will all miraculously be on vacation from the 19th to the 23rd. Or we already know that Lemoyne has hearings on the 23rd and the 26th. 27th, I think that he already has hearings on those dates. Actually he said he couldn't do the hearing on the 29th already. Man, it's almost like there's just this tiny window right here, and I would wager that someone won't be able to make that hearing too. Gosh, shucks. So there you go. I've informed counsel for all parties regarding this vacation. Why a prepaid trip? And he's informing the court 6 days? 6 days? Well, 7 days. 7 days prior to a prepaid trip and 8 days prior to an out-of-the-country wedding that they won't be available. Whew, sorry. We just didn't mention that. When did you prepay it, John? Today? Did you prepay it on the 7th of August? Like, I can do a prepaid trip today. Heck, I prepaid my HawaiiCon trip the other day. It's a prepaid trip. I could set a prepaid trip tomorrow as soon as business opens. Quelle coincidence! Did Ty tell you he was going to file a motion to strike today, John? I wonder if Ty said, "Oh, by the way, we're gonna file a motion and we're gonna ask for a hearing right away." Oh man, I can't make it. Well, that's how that goes. All right, let's take a peek at Ty's filing here. You need to say this at least a month prior at work. Well, let me just. Is your work as flexible as a court that compels your attendance by law? Good Lord. So here is this is a 5-page motion to strike. Plaintiff's motion to strike or disregard defendant's late filings. To the Honorable Judge of said court, Plaintiff Victor Mignana requests that the court strike the documents defendants filed in support of their TCPA motions to dismiss, which were filed after the deadline to file their motions to dismiss, and disregard for the purposes of its TCPA analysis all affirmative defenses filed after the deadline for their motions to dismiss. Yep. That's the deadline for Defendant Funimation Production LLC's motion to dismiss under the Texas Citizens Participation Act was July 15th, 2019. Funimation service date was May 14th, 2019 by Rule 11 agreement filed May 29th, 2019. Its motion to dismiss was due 60 days later. 60 days after May 29th was July 13th, a Sunday. Hence, Funimation's deadline was extended to Monday, July 15th. Wait a minute. Must have been a Saturday. They must have gotten the days wrong. Whoops. July 13th was Saturday, not a Sunday. It was Saturday. So there you go. Oh, they lost the case. Good job, Ty. You lost the case again. Andrew Morgan says, I live in a lovely city a few miles west of Estes Park. I will keep my eyes out for a coward. No, 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 no. I mean, I know you're joking. I know you're joking, but I want to be very clear. Be very clear. No one at all should have any interaction with John Volney, no matter where he is. That's not a thing. I will actively, as I always do, despite the protestations of Law Twitter and everybody else who wants to assert that I am inciting harassment. Please, under no circumstances, if you encounter any party or lawyer, like if you hear the Darth Vader clack clack of Lemoyne's cane, if you hear that coming down the hallway after you, just run the other way. Just run. Just run. He might have mosquito parts growing out of him. It could be a horror movie. You don't even know. Just run. Don't talk to him. Don't address him. Do not interact with these people. If you happen to, I don't even know what John Volney looks like. If you even hear a guy's name named John at a restaurant in Estes Park, Colorado, just ignore it. Let him spend time with his family. Ignore it. There's no reason at all to discuss in any way any of this stuff with them. I do not encourage that. I do not encourage, and same thing as I've always said, I do not encourage talking to the voice actors at cons or anything. If you're at a con, be at a con. That's it. Period. If you're being chased by a crippled Darth Vader, just walk slowly in the other direction. You'll outpace him by a mile. Leave a trail of inhalers going a different direction, and then backtrack and go the other way. He'll follow him. He'll follow him and have a giant CPAP at the end, and he and T. Greg can have their homoerotic fan fiction can happen later outside of your view, and you will escape to a different state by that point. Whatever you need to do. Okay, next. Background. Funimation filed its motion to dismiss on July 1st, 2019. Funimation subsequently filed Funimation Production LLC's supplemental brief in support of its TCPA motion on July 29th, 2019, i.e. 2 weeks after its motion to dismiss deadline, and filed Defendant Funimation Production LLC's supplemental evidence in support of its TCPA motion to dismiss Funimation's second supplement on August 6, 2019. See, this is good. They're branding it. The first one wasn't a supplement. It was a brief. It was a supplemental brief, but it's not a supplement to the motion. It's just a brief in support of its thing. But they branded them both as supplements that are identical in a way. That's great. i.e. 3 weeks after its motion to dismiss deadline. The deadline for defendant Monica Rial and Ronald Toye's motion to dismiss under the TCPA was June 18th, 2019. Let's go ahead and check their footnote. Rial and Toye were served on April 19th, 2019. Rule 11 agreement dated April 19th, 2019. Hence their motion, to dismiss would have been due 60 days later, i.e. by June 18th, 2019. Texas Civil Practice and Remedies Code. And they filed on June 18th. They filed on June 18th. Plaintiff agreed to a joint motion and agreed order extending this deadline to July 19th, 2019. Oh, wait. So they filed it on... Oh, here we go. Rial and Toye filed their... That's by Rule 11 agreement. Rial and Toye filed their motion to dismiss on July 19th, 2019. Subsequently, Rial and Toye filed defendants Monica Rial and Ronald Toye's supplemental affirmative defense on July 26, 2019, i.e. a week after the deadline for their motion to dismiss, and defendants Monica Rial and Ronald Toye's supplement to motion to dismiss Rial and Toye's supplement on July 30th, 2019, i.e. 11 days after the deadline for their motion to dismiss. Argument and authority. Says a motion to dismiss a legal action under the TCPA must be filed no later than the 60th day after the date of service of the legal action unless extended by trial court for good cause. Let me give you a hint. For good cause. Have you guys seen the movie Liar Liar? Where he's like, objection, grounds. It's destroying my case, right? If you're you're not being granted good cause to extend the deadline because they pointed out all of the deficiencies in a motion to strike. That's not good cause to extend the deadline, okay? The issue here is whether the TCPA permits supplementing a motion to dismiss after the 60-day deadline is passed. The TCPA does not state whether supplementation after the 60-day deadline is permitted, unlike, for example, the procedural rule governing summary judgment motions, which permits the filing of supportive evidence up to 21 days before the motion's hearing date. Uh-oh. Hey, what was that? Hey, remember, hey, Lane, if you're out there, hi, Lane, if you're watching. I know you won't admit to you're watching, but hi, Lane, if you're out there. Remember when you said that procedurally TCPA is handled the exact same as Texas rules? I'm paraphrasing. It's Texas Rules of Civil Procedure 166AC, the motion for summary judgment. Remember when you mocked me and you said I didn't know that all evidence would be ruled in the light most favorable to the non-moving party, as it is in Rule 166AC, which is a summary judgment rule, which they just cited. Remember that, Lane? I'm curious how you're going to take this argument, Lane, that Congress actually has procedural rules that they have developed and implemented via statute, and they do in other places go ahead and cite a specific deadline if they want to extend it beyond the actual deadline. They've done that. So now you're going to have to read into it that Congress, by not saying anything, meant, well, it means any time before it, and then you naturally have to say that it goes up to and including the date of the hearing. They could supplement it, in which the non-moving party would have literally no opportunity to review and respond. That's what you would have to argue as the logical alternative to this, is that Congress is silent when there is no deadline, not that Congress speaks when there is a later deadline. Good luck with that argument. Rather, the TCPA imposes an express deadline for filing the motion to dismiss based on the date of service, and reviewing courts consistently have held that this deadline is firm. Braun versus Gordon, Jordan versus Hall, Miller Weisbrod LLP versus Yamas Saforo. That's not llamas, I don't think. Maybe it's llamas, maybe it's Yamas. I don't know. It's Texas, you can never tell. When interpreting a statute, the court begins with the Bullock, I'm guessing, is who drafted this, because Bullock tends to draft the arguments. Sometimes it's Ty, I don't know, whoever, Ty or Bullock, or maybe it was Amazon Prime. I should have figured they'd go ahead and make the argument for me. Let's see. Oh, Darkman McEdgeface, please yell, don't you see? He is Vigo. You are like the buzzing of flies to him. Also, remember to check your email or DMs. Graded Point 5 has been trying to book you for weeks. We just want to party with you, fam. Yeah, I do. I've just been so... I've seen the email. It's not your fault, it's mine. When interpreting a statute, the court begins with the statutory language as the, quote, surest guide to what lawmakers intended, and, quote, the alpha and omega of the interpretive process. Beving versus Beatles. And Texas Court of Appeals in Fort Worth. There we go. So that's direct authority. And the court presumes that, quote, the legislature included each word in the statute for a purpose, and that words not included were purposefully omitted. Grant versus Pivot Tech Solutions Limited, and Hearst Newspapers LLC versus Status Lounge Incorporated. That's Texas Appealed Austin, Texas Appeals Houston. Petition filed. That means that technically the Supreme Court could review this decision. I don't know why they filed the petition. Who knows? And this one did not petition for cert. Rehearing denied January 30th, 2018. Miller Weisbrod LLP, which is cited up here as well. Let's just say that that's pretty much settled law. Indeed, the court must enforce the statute as written and refrain from rewriting text that lawmakers chose DeAngelis versus Protective Parents Coalition, Texas Appeals, Fort Worth, no petition. And should be disinclined to apply any extra textual tool of interpretation or engage in open-ended improvisation in the face of an unambiguous statute, citing Beving again. Here, the TCPA unambiguously states that a motion to dismiss must be filed by a date certain, 60 days after service, and that a hearing must be conducted by a date certain. But it does not state that supplementation is permitted after that deadline. Since the court is to presume that the legislature intentionally omitted any provision for supplementing a motion to dismiss after its filing deadline, Grant, Hurst, and Miller-Weisbrod, the court should presume that the legislature did not authorize supplementation after the deadline for the motion has passed. Now we get to some exposition. What is the point of a deadline if the movement can continue supplementing after the deadline? A darn good question, isn't it? Do you guys, after your deadlines, do you get to supplement your original work and have it applied retroactively to the original work? Do you get to do that? Like if your job says I need a report by Thursday, and you file a shell of a report on Thursday, you give it to your boss, and then say like 2 weeks later, you're like, oh, by the way, here's some stuff that I left out of Thursday's report because, well, you know, I wanted to. If defendants are permitted to continue supplementing their motion after the deadline, they essentially are granted a perpetual opportunity to file their motion to dismiss and defeat the purpose of the 60-day deadline. See Texas Rules of Civil Procedure 69. Supplemental pleadings constitute separate and distinct parts of the supplemented pleading. So there's a rule right there, Texas Rules of Civil Procedure number 69. 69, man! Says supplemental pleadings constitute separate and distinct parts of the supplemented pleading. So you don't get to just incorporate by supplement what they are. This is a new thing. It's beyond the deadline. See also Miller-Weisbrod. We see nothing in the statute or its history and purpose to indicate the legislature intended to create a perpetual opportunity to file a motion to dismiss. Oof. Moreover, plaintiff is put in the position of trying to file a response to meet his evidentiary burden and preserve his case that hits a constantly moving target. First filing must have been early access filing. Furthermore, in determining whether to grant a motion to dismiss, the court is to consider the parties' pleadings and shall dismiss if the movement establishes each essential element of a valid defense by a preponderance of the evidence. Hence, a movement's amendment of its pleading after the deadline for its motion to dismiss modifies the basis for dismissal of the non-movement's case after the TCPA's 60-day filing deadline. To consider additional defenses filing after the filing deadline would likewise defeat the TCPA's 60-day filing deadline. It's a good argument. It's actually 69 dudes. What did I say? I forgot. I don't even remember what I said. Prayer, wherefore plaintiff requests that the court strike Funimation's first supplement, Funimation's second supplement, and Rial and Toye's supplement. Disregard Rial and Toye's supplemental defense for purposes of the court's TCPA analysis and order defendants not to file any further affidavits or evidence in support of their TCPA motions. Plaintiff further requests that the court award him such other and further relief to which he may be entitled at law or in equity. Plaintiff prays for general relief. It's delicious. It's a delicious argument because it makes all of the sense in the world. Why on earth would we allow these people to just keep adding to the argument and burden the plaintiff up until the day the TCPA goes out? Oh, I said man. Sorry. 69 dudes. There you go. Well, there you have it, guys. That's the documents we have for today. That's the documents we have for today. Oh, boy. Oh, boy. We'll have to see. We'll have to see how it goes, right? That's the best part. We get to find out how this goes, and probably soon. Someone said, wouldn't the 13th be open? Maybe. Maybe. I'm not sure the court will have the 13th open as a date. Although maybe that's the case. Maybe Beard Airs, Bullock and Hughes will just go ahead and say, well, they're going to be out and we need a ruling on this as fast as possible. So we want it on the 13th. I don't know. I guess it depends on how they calculate the 3 days. We'll see. And I don't know if it's after the 3 days or if it's, I'm not sure how the calculation of that works because I'm not really into Texas civil procedure that deep. So it's not my job. It's not my job. We'll find out, right? I'm sure there will be a notice of hearing filed like tomorrow, if I had to guess. This was filed at 4:42 p.m. They likely just didn't have time to get the court on the phone to determine the next calendar date. Point of personal privilege. Stop using gender language. All right, let's hit the super chats and then let's wrap up the stream. I think we can wrap up a little early tonight. I'll go to Twitch after this because I am a Twitch thought. I'm dedicated to being a Twitch thought. Yeah. Should I put on a wife beater? I could probably do that. Why am I yawning so much? I'm not even tired. I mean, I'm just generally tired, but I'm not actually. It's not like I want to go to bed. How's that? No one important. Oh, yeah. So, oh, wait, I forgot. I'm leaving something out. Don't leave yet. I've got an announcement. I meant to make it an hour ago, but I'm glad I waited. I'm not that glad I waited, but either way, we got a lot of people watching. Don't leave yet. Ty has informed me, as you know, Akiva Cohen has filed a grievance against Ty with the State Bar of Texas. Akiva Cohen has filed a grievance with Ty Beard, the State Bar of Texas. And Ty Beard alleges that Akiva Cohen lies under oath several times in that statement. Well, here's the thing, y'all. What have we been talking about here? We've been talking about a TCPA. Should we pull up what the TCPA statute says real quick? Let's pull up the text of the TCPA. Civil Practice and Remedies, Chapter 27. Here we go. Let's just go ahead. We've got this will be quick. Don't worry. Oh, we gotta zoom this in a bit, huh? Okay. Why can I not? It's like just, how is this? You're too big. Okay. Here we go. This is the exercise of the right to petition, communicate, blah, blah. Let's see. Governmental proceeding means a proceeding other than a judicial proceeding. Legal action. What is this? Legal action means a lawsuit, cause of action, petition, complaint, cross-claim, or counterclaim, or any other judicial pleading or filing that requests legal or equitable relief. Official pleading, official proceeding means any type of administrative, executive, legislative, or judicial proceeding that may be conducted before a public servant. Public servant means a person elected, selected, appointed, employed, or otherwise designated as one of the following, even if that person is not yet qualified for office or assume the person's duties. Officer, employee, or agent of the government, a juror, an arbitrator, referee, or other person who is authorized by law or private written agreement to hear or determine a cause or controversy, an attorney or notary public when participating in the performance of a governmental function, or a person who is performing a governmental function under claim of right but is not legally qualified to do so. Now, those definitions are important. Why? Motion to dismiss. Following yet? You following yet? I hope you're following this. If a legal action is based on, relates to, or is in response to a party's exercise of the right of free speech, right to petition, or right of association, that party may file a motion to dismiss a legal action. What's a legal action? Legal action means a lawsuit, cause of action, petition, complaint, cross-claim, or counterclaim, or any other judicial pleading or filing that requests legal or equitable relief. If a legal action is based on, what's that? Does that mean that under the Texas Citizens Participation Act, as it is written, that an ethics investigation initiated by the State Bar of Texas in regards to someone's exercise of free speech can be slapped under the TCPA? Oh, no. Oh, State Bar of Texas. Why would you initiate a legal action? Why would you do that? Oh, God. Oh, so sad. I have been authorized to inform you that at present, Ty Beard intends to file a TCPA motion to dismiss his ethics investigation initiated specifically on his exercise of his right to free speech on a matter of public concern, very public. They've talked about how many very important, very employed attorneys are talking about this case, right? Right? They've stated over and over that this is a matter of public concern. Hell, it has to be. It involves a public figure, right? According to them. And all sorts of things in judicial proceedings. Oh my God. What is this? Matter of public concern includes an issue related to health or safety, environmental, economic, or community well-being, the government, public official or public figure, or a good product or service in the marketplace. So there you go. We're going to talk about, this is court, baby. This is court. This is about community well-being. This is about goods, products, or services in the marketplace, e.g., Beard, Harris, Bullock, and Hughes's product that they put into the marketplace, their legal services that are being criticized. I think we might have slappable action here. Oh, and if you're wondering, yeah, there is apparently some case law. Goes ahead and supports it. Now, the really funny thing is the TCPA, I believe, has been amended to no longer allow ethics investigations to qualify under the TCPA. However, that doesn't go into effect until September 1st. Too bad you filed your ethics complaint too early. Now I guess Ty will be able to file a anti-slap against the State Bar of Texas. And I guess the Texas State Bar would have to pay the legal fees because that's what's in the relief, right? So any fees brought up by Beard, Harris, Bullock, and Hughes, or any fees incurred through their representation of Ty, or maybe he'll hire outside counsel. I don't know. But any fees incurred would be paid by the State Bar of Texas. And I think the sanctions would have to be high. Abusing a governmental power to silence the free speech of an attorney. Oh my God. As for Miss Akiva Cohen, let's talk about, there's one more statute I want to bring up. Hold on, let me pull it up here. Miss Akiva Cohen. Well, let's see here. What's this? Can we make this bigger? Make it a little bigger. 18 USC 1343, fraud by wire, radio, or television. This is a federal crime. Whoever having devised or intended to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises transmits or causes to be transmitted by means of wire, radio, or television communication in interstate or foreign commerce, any writing, signs, signals, pictures, or sounds for the purpose of executing such scheme or artifice shall be fined under this article or under this title or imprisoned not more than 20 years or both. If the violation occurs in relation to or involving any benefit authorized, transported, transmitted, transferred, dispersed, or paid in connection with a presidentially declared major disaster or emergency, blah, 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 it's worse. So let's see. Did Akiva Cohen devise a scheme or artifice to defraud the State Bar of Texas into taking action against an attorney based on his hurt feelings? Did he lie in a sworn statement made to the State Bar of Texas? He lie under oath? I don't know. Maybe he did. Maybe it's not a crime. Maybe it is. That won't be up for me to decide or you. It might be up for a federal prosecutor to decide. Maybe. Maybe not. Who knows? He knows. But my goodness. You know what's funny? Now, to Miss Akiva Cohen's credit, I'm pretty sure she didn't say that I was committing federal wire fraud with the GoFundMe. But a lot of Kick Vic lawyers, law Twitter lawyers or whatever, have accused me of federal wire fraud, saying that I somehow, despite being very open in not only the GoFundMe, but in literally the entirety of the campaign, the GoFundMe campaign, and all of my discussion on it, have been outright honest. Aside from the parts where I'm being obviously satirical or sarcastic, but have been 100% honest and clear about what you're donating to. In fact, going so far as to cover the lawsuit so people can see where the money is going specifically, as specific as you could ever find out. Because I'll tell you something. If you offered right now to go pay for your best friend's lawsuit, say, no, I'm going to pay all of it. It's $1 million. Here's $1 million check to the attorney's firm. And then you go to that attorney and say, you show me the billing history. I want to make sure I was charged accurately. They'll say, I need to check with my client. That's privileged information. They'll have to disclose it to you. So outside of literal specific itemized billing, which I cannot even obtain, much less show you, I show you the work product that is there constantly with relentless vigor. I'm accused of federal wire fraud by a bunch of fraud attorneys. And one of their very best and brightest may have engaged in his own wire fraud scheme. I don't know if he did. I'm not saying he did. Not at all. That's not up to me to determine. But gosh, I can imagine that would be part of the argument. That not only did this guy lie under oath, but that in doing so, it may constitute wire fraud, and they would recommend review by a federal prosecutor to see if wire fraud occurred. But what do I know? I hope the butt hurt was worth it, Akiva. I hope the butthurt was worth it. So there you go. State Bar of Texas is on blast. At present, Ty intends to file a motion to dismiss under the Texas Citizens Participation Act. And so the State Bar of Texas will have to make a prima facie case why it is instituting a legal proceeding through the disciplinary section. The prima facie case will require them to articulate, based on the evidence provided, to articulate a prima facie case. So there you go. And then Ty's affirmative defense would be the first one I can think of is his First Amendment right to speak. So we'll see how that goes. I mean, maybe the State Bar of Texas will withdraw their thing. I don't know. That'd be that'd be between them and Ty. But God, I can't. I do declare, it is warm and funny in the South. It is warm and funny in the South. So there you go. All right, let's hit these super chats. Thanks for hanging out with me through that. Oh, also, you guys might want to check out akivacohen.com. I guess we could. I've heard that akivacohen.com exists. Let me Oh no. Oh, that's unfortunate. Let's see. I'm not going to show this on stream. You guys will have to look for yourself. Oh, man. There's even a link to his biography on there. Oh, God. But I believe, I have heard that website is up for sale. So I don't know if anybody wants to make an offer on that one, but akivacohen.com appears to exist. And appears to be up for sale. It's not me, by the way. I don't own akivacohen.com. I don't own it because if you know anything about me at all, it's that I am not a technology. I don't even know how to buy a website domain, a web domain. So, but that's funny that that's out there. All right, here we go. Let's do justice chats first here. Hated 7 Days to Die says, hey, Nick, the con sloth missed you. Let's try another sloth. Kilo Bravo says, hot dog. Short Round says, someone should check on Greg Douchette. www.blackfacelawyer.com. It's safe for work and hilarious. Bad police advice 16. Ladies, if you are fat, hide your drugs in a sweaty boob roll and no officer will go look for it. Ron, how much to fight Nick? Yeah, apparently blackfacelawyer.com. Let me... Is there... Oh, okay. All right, let me pull that up on stream here. I will pull this one up on stream because it's not as, I know who this is about, and that lawyer, I think, has made peace with this. So blackfacelawyer.com. Here we go. Look at that. Oh no, you guys can't see it. Dang it. Boomer. Here it is. Blackfacelawyer.com. What is that? Is that T. Greg in full African garb? Is that his current girlfriend or the wife that he abandoned? Which one is that? Wow. A night in Africa at NCCU Law. Cool. Seems like he appropriated some culture there. That's very interesting. I'm going to guess that website's for sale too. All right, next, we've got Kilo Bravo says, like Vic, you are a unicorn, Nikki. Hated 7 Days to Die says, I believe my masks come with my name. Yours do. Somehow people can do it. Kilo Bravo says, puppy attack. Kilo Bravo says, GFM. Hated 7 Days to Die says, guys, don't forget to like the video. Kilo Bravo says, why Ty is away, the Knicks shall play. Kilo Bravo says, somehow you boomered my mask, Nikki. I didn't. Hated says, whenever I see this tiny stony wooden looking whiskey glass, I think of the Last Crusade's Holy Grail. You chose wisely. Jay says, I still find it amusing how they don't mention the abuse, bullying, and harassment perpetrated by Kick Vic or the abuse the defendant subjected Vic to for months. Well, I mean, who knows? Kay says, I'm so tempted to try and write a donation that will get me included in a Lemois filing, but I know I'd freak out about it when I get sober, so I'll just suggest that the best and only form of payment he could get from Veronica would be one of Ron's lungs. Whew. An organ pup. Hated says, feels like the defendants are still playing as a team. When does the real infighting start? Probably after TCPA. And then he says, yes, think of the TCPA for the Texas bar. And you know what? You know what the great thing about motions like a TCPA against a government entity are? They're going to pay when the judgment comes. They'll pay. James, don't worry about it, buddy. I see you. I see you. No one important says, Amanda Wynn Lee confirmed to be Kick Vic, but with someone as nasty and has the mindset of believe victims mindset, it shouldn't be a surprise. Amanda Wynn Lee has been that way for a long time. That's not new. What is this? Why are you guys saying Bob Rekieta? Very weird. Very weird. Josk says, I don't know if you're following along, but what do you think the chances are of the lull suit continued? The dick strikes back, if you will. GFY, buddy. I haven't seen anything about that. Who's gonna sue who? Is Dick gonna sue Maddox for some reason? That'd be weird. Joni Baloney says, child abuse is the cause of society's problems. That's, yeah, probably a lot of it. A lot of it. Josh Calhoun says, can you recommend a good criminal defense attorney in Arizona? Not off the top of my head, but I could maybe find one. I don't know. Caleb Lambright says, you're late, Nick. You really are lazy, Nick Gurr. Oh, hey. Oh, come on. Bad Vibe says, you Limerick fund is paid. Viden the Cold One says, you are a godsend to this insomniac. Don't worry. We love you, Nick. We love you. Guns Down in Hail says, Nick is a Fed. Prove me wrong. Prove me wrong. How will they prove the negative? Neil Purcell says, abandons the show and fears turbo tunnel. Cormoran says, they went ape poop over your chimp out comment. Yeah, they did, didn't they? God, they so mad. The one says, can you say Changu? Okay. Cesario JPN says, hey Nick, when will Rekieta Chair Sama have a collab with EVS Chair? EVS Chair is up to a collab according to Chair's Twitter account. Epic discussion. Should be riveting. I think they'll swivel back and forth between the topics, rest on the arms of their arguments. The one says, yo no cara negra. Samantha Schoner says, I had a dream last night that Shane came to my house and tried to eat my shoes. You think I should sue him for dream harassment? Yes. Yes. Fatal System Error says, I'm way late and gay tonight. Here's a couple. Hey, thanks, buddy. By the way, Fatal System Error sent me something. I don't know if he's still watching. Is he still watching? He is. I should show this. Fatal System Error sent me a gift. We've got to be very careful here. This is a skull, decanter, and shot glass set for the whiskey or the rum. I think it really goes well with the rum. So thank you. Thank you for that. This is great. Lady Rackets loves it as well. So thanks, buddy. I appreciate that. Cynic in Chief says, for your 75K, have legal on for 2 hours. Oh, God. I'd rather eat 2 peppers. Dash Attack says, Vic was supposed to do a signing at Open Jar Studios. It's been quietly canceled, but they won't say why. Could they have been threatened? No, my understanding is that Vic has found a venue that is in the same area that will give him a longer signing time. So I think there's Imish is live, has on Twitter had announced that or something. So check out Imish on Twitter to see the details of that. Or Squally, I think. I don't know if Squally's on Twitter, but there's something going on there. And I don't know exactly what it is. Oh, looks like I am confirming my Friday night guest will be Josh Moon, owner and feeder in chief of Kiwi Farms. Josh will be on Friday. So there's that. And that'll probably be a show that's not super related to Vic, but should be very, very interesting. We're going to talk about the ESA doxing and all of that junk. All right, Dash Attack. Oh, wait, no. Patrick Radcliffe says, Yellow Flash does a horrible impersonation of you doing an impersonation of Lamoni. Oh, that's got to be good. Trump 2020 says, please talk about Senpai's home and his strange cybersex roleplay DMs with girls online. What are your thoughts on Senpai? I don't know anything about that, man. That's like my focus is the legal aspect of the case. There's always drama in online stuff, and I have no time for it. I really don't. So whatever people like to do in their Discord DMs, I mean, whatever gets your flagpole greased, man, is up to them. I don't care. I don't have an opinion on it. Never had a bad interaction with Senpai, so fine by me, man. I don't really think the drama is productive, but whatever. It's not my job to deal with other people's stuff or to police what they do. Brian W. says, knives look great. Good for stabby. Just kidding. You next. Infernal Iris says, will you be able to confirm the winner's identity if we donate anonymously? I don't know how to do that. Maybe. Not easily. Rocky Top Otaku says, there once was a manlet named Toye who overindulged on pure soy. He protect, he attack, he carry your snack. Is he a sheepdog or just whipping boy? Oh. Mario Carter 13 says, Money Badgers got caught off guard. 3-year internet lawsuits are hard. Lost to the Mary Sue and Calgary Expo 2. Don't hire a lawyer disbarred. Oh, that was a limerick. Allison Tiemann reached out to me the other day to kind of give an update on their case. I haven't been following it. I need to circle back to her. Mostly thinking out loud and speaking out loud right now. Eggs Benedict says, Lemoyne as Austin Powers. Let me ask you a question. And be honest. Do I make you horny, baby? I don't know how to do... Oh, God. Do I? Do I make you randy? Dang YouTube censoring. I don't know if that's... Is that... I don't know how to do Lemoyne as Austin Powers, but that was an effort. D for effort? Stephen Avery says, there was a poor lawyer, Jay Sean, whose law shingle he took to go pawn. For his lungs they'd not pay, because they're wasted and gray. And his willy, girls said, was a yawn. Oh, no! Oh, no! Oh, no, don't send a copy to my email of the donation. If I do that, I'll set up a specific email for something like that. The one says, yo vio muchos changos and enojados. I don't know what I'm saying in Spanish, so hopefully it's nothing terrible. Shining Nebula says, if you ever wonder why SJWs are weight challenged, it's because they want to have their cake and eat it too, all day, every day, 24/7. These court papers here are just another grand example of it. Cyber Metal Sonic says, is Jamie Markey going to have to do a deposition too? Assuming they pass her TCPA. Yeah, of course. Of course. I totally want to see her sweat answering all the questions on camera, lol. I stopped paying attention at you wanting to see Jamie Markey sweat, and that's disgusting. Kalinka Pavlova says, has Mika potentially put her head, oh goodness gracious, put her head on the chopping block by saying she's the one person in charge of their contractors? I have no idea. I have no idea. I think they're all on the chopping block right now anyway. It's like Sony's walking through there with the scythe right now saying, harvest is coming. Trump 2020 says, is Supergirl hiding because Senpai cucked her? No idea. Zyber Warrior says, pretty sure all VAs violate Section 10 of the contract. Yep. Andrew Olson says, have you seen The Boys? Homeland looks like VLC. I've not seen The Boys. Oh, I've seen an ad for The Boys, but I don't know what it is. No One Important says, yes, fire all the VAs at Funny, clean house. Not just the VAs, but the management staff. They're the ones who are on block. Bob Oxide says, it looks like Section 2 that Scott targeted Vic. Instead of saying monitoring all VAs equally or all VAs involved with Broly movie, just your view. George Lopez says, here's money I could have spent on Funimation subscription. Hey, thanks, buddy. Serial Foxity says, Scott, son, gird your loins. Nick Sex says, Nick, please say a sphincter says what? Travis the Bard says, what do you get when you cross Monica and Twitter lawyers? A Klondike bar. Frater J says, where do we go? Frater J says, see how pro Ty is by calling Lemonhead just Sean. Scott E. Wolfie says, if you can, Mr. Rekieta, please pin the other comments I made on Vic and Monica's depositions. If you do, I'll timestamp any 9 past streams. They're just hard to find, Scott. That's the only problem. And it's not you, it's YouTube. But I'll take a look, buddy. Asphyxiation says, pray for the pants and my willy. Sorry, bud. Brooklyn Storm says, Rekieta Law, making law fun, one video at a time. Andrew Morgan says, sorry, Nick, didn't mean anything like that in my last chat. Would just be friendly or avoid altogether. I know you did. It's not you, Andrew. It's no harassment, not our style. Yeah, it's not you. It's for the benefit of the people who would read that disingenuously. That's all. Devil May Cry 5 says, oh my goodness. I was really happy Ruben Langdon defended Vic. A lot of these voice actors are afraid to defend him because it makes him the next target. Bad Vibe says, are these actions by defendants evidence of collusion and conspiracy? Well, the actions are my suspicions, not necessarily confirmed yet. It's a Cakewalk says, this an EA filing? Buying more supplementary DLC? Dallin Zero says, everyone type, Nick, go to bed, you boomer, in chat. Rude. Oh, I missed this one. Ogentai says, with the case likely entering a lull until the September 6th hearing, can we do a review of the other TCPA cases J-Dolph has lost? I don't know that he's lost any or won any. I asked what his record was. No one's posted it yet. I just know that he has allegedly 5 TCPAs on appeal. Let's see if he's acted like a developmentally delayed bundle of sticks in those also. Oh my gosh! The one thing I don't like about narcolepsy is that I yawn constantly. The rest of it doesn't bother me that much. Bad Vibe says, to Mrs. Cohen, how embarrassing. Sakaki Onsai says, I think I found a new microbrew named TCP Ale. Takun 513 says, cause I'm a cheapo. Hey, thanks, buddy. Sarbamba says, Nikki and Mr. Mediocre will feel the wrath of Agent 19th and Montograph soon. Bilk-faced lawyer will lose yet again. Rip. Love you, Nick. Hey, love you back. Can't wait to see Monty in court. I can't wait to physically see Monty in court. That would be something. Blaine 20 says, what's the difference between a good or a product? Oh, that's a long question we're not going to get into. Esme Illis says, Josh, thanks, Nick. Hey, my pleasure. I always aim to please using other men. Austin Heartless says, in Lemoyne's voice, shag me, con slut. Shag me hard, baby. Shag me like one of your French rolls. All right, guys. All right. Oh, wait. Knight of Hopex says, every gasp you take, every choke you make, every cane you rake, every leg you break, we're dismissing you. Oh, my. Oh. That'd be a funny Lemoyne parody song, man. Just flesh that one out. Every breath you fake. It'd have to be a fake breath, right? Okay, well, speaking of songs, let's get the outro music going. Yeah! Yeah! Beige Devil says, why do your haters always talk crap about the alcoholism but not the narcolepsy? I don't know, they could go for the real thing when they go for the fake thing. So... I'm sure my alcoholism really came through with my one shot of which is my one glass of Aberlour Abundna, which is apparently shot after shot. What's the point? Why argue though? Embrace it. Embrace the fake alcoholism. So, closing thoughts before ending the stream. Closing thoughts are simple. Go check out whatchamacallit. Jawbreakers God King on Indiegogo. There's 1 hour left. Go help push Zach over the 200K mark. I could check it real quick. Jawbreakers Indiegogo. There we go. Jawbreakers Indiegogo. So close. So close. It's at 196,781. Meyer's a good guy. Really is. And he's putting a nasty spot. So here's your last chance. I'm gonna casually stroll through the art here, and don't be alarmed by the giant anime titties that are coming. Well, not anime, I guess, comic books. But here you go. So he says it's a good old-fashioned action romp, dealing with the harsh realities of a mission that you can't win. But yeah, go check it out here. Here you go. Here's the pinup that comes with it. So if that's your poison, make sure you pick that poison. Here's some more art. All sorts of stuff going on. There's space involved. Space is cool. We got guns and tanks, dudes with knives, ninjas and shinobis getting chopped up, and we got a hero laying on the ground, and this dude with helicopters all around him. How can you beat it? How can you beat it? Anyways, all right, guys. Join me on Twitch, probably 15 minutes or so while I get some snacks and go to the bathroom, take care of some stuff around the house. I'll see you over there. I'll get the Twitch stream started before that, but I'll probably actually be active in about 15 minutes. Links in the description. Thanks for hanging out, guys. I'll see you soon. See you soon. Nasenda says hello. Well, hi. And with that, peace. Peace.